Hey friends, hope you all are doing well and taking great care of yourselves. In the first video, we spoke about the consequences and the cost involved and the judgments which may come to rescue while dealing or defending the proceedings initiated alleging the donation to the political parties as bogus donation. The link is given in the description box. Now the issue comes is, what if one surrenders and in the return which he has to file in response to a notice under 148 does not claim the deduction on account of that alleged the donation which alleged to be a bogus donation. The assessee submits that he does not want to do that just to buy peace of mind. Finally, let us assume that the returned income becomes the assessed income because now the returned income is without claiming the donation as deduction. Whatever tax and interest which has already been paid while filing the return or maybe while even responding to the notice issued under section 148 clause A, 148A clause B, in response to that notice itself, the taxes and interest have been paid. Now in that case, can there be a penal consequences, or let's say the department has initiated penal consequences. Now can assessee be defended in that particular case? Today in the morning only I read one judgment. The judgment is of Honorable Ahmedabad ITAT, and that's why I thought it appropriate to bring this judgment to the knowledge of everyone. The facts are slightly different, but once again, one may take his individual call after considering the facts and the judgment. So first of all, the judgment is that of Ahmedabad ITAT. The date of the judgment is 10th of February 2023. And the case is Jigneshkumar Babulal Tiwari, ITA number 352, Ahmedabad 2022, relating to assessment year 2011-12. What has happened in this case is, assessee is a salaried employee. Assessee has filed return of income, offering income from salary and the other income. He had received a certain amount from LIC. He was under the belief that amount received from LIC is not liable to be taxed. He did not offer that particular amount to tax. A notice under 148 was issued. Of course, in that case, it was under the old law, and 148 notice was issued, and he filed that, or he offered that income from LIC in the return of income, which is to be filed in response to that particular notice. Now the and the return income become the assessed income now. So he paid taxes in while filing the while responding to the notice issued under section 148 or while filing the return itself. Now can there be a penalty? Let me first take you to the facts so one can have a better clarity. The facts in brief, that the assessee is an individual and employed with the Torrent Power Limited. In the return file under section 139 of the Act for the year under consideration, the assessee declared income of rupees so and so under the head salary and other income. Subsequently, it was found that the assessee during the year received an amount of rupees so and so on account of the premature surrender of LIC, against which the assessee has paid premium of rupees so and so only. Hence, the assessee earned net income of, let's say, 4 lakhs only. However, the same was not offered to tax by the assessee. Therefore, the assessment was reopened by issuing notice under 148 of the Act dated 29 March 2018. The assessee, in response to such notice, filed return of income under section 148 of the Act, wherein he offered the additional income of 4 lakh rupees, and the AO accordingly framed the assessment and accepting return income declared in response to a notice under section 148 of the Act. However, the AO issued penalty proceedings on account of concealment of income. Now let us see, this is of course a single bench judgment and single member bench judgment. And now what has happened in this case, let me take you straight away to the relevant paragraph here. Yes, the member says that while giving a judgment or rather in the judgment, I also find support and the guidance from the judgment of Honorable Gujarat High Court in the case of PCIT versus Gujarat State Electricity Corporation Limited, reported in so and so, where the Honorable Court has held that no penalty can be imposed when the assessee made bona fide mistake and corrected the same on realization of the mistake. So that is, he relied on this Gujarat High Court decision, and finally they said that penalty cannot be levied. There are few other judgments as well which I think one should quickly go through so that one can have a better clarity. The first judgment is here in the case of Allahabad High Court in the case of Dampur Sugar Mills Limited, which is reported 90 ITR 236, wherein they have said that the effective return for the purpose of assessment is thus the return which is ultimately filed by an assessee on the basis of which he wants his income to be assessed. But when an assessment has to be made, the assessee is given a right to file a correct and complete return if he discovers any error or omission in the return filed earlier. The assessment can be completed only on the basis of the correct and complete return. Once a revised return is filed, the original return must be taken to have been withdrawn and to have been substituted by a fresh return for the purpose of assessment. So this particular judgment one may come to the rescue. Another judgment is in the case of Rajiv Garg 2008 175 taxman 184 Punjab and Haryana. What has happened in this case is once again, so penalty matter assessment year was 98-99. The assessee has filed return of income declaring capital gain on the sale of shares. Assessing officer processed said return under section 143(1)(a). Subsequently, assessing officer on the basis of information received from the revenue authorities that the sale of the shares on which capital gain had been declared by the assessee in the original return was bogus, issued notice under 148 to the assessee. In response to the said notice, assessee filed revised return surrendering the entire amount of sale of proceeds of the shares allegedly in order to buy peace of mind and to avoid hazards of litigation and also to save himself from any penal action. So once again they say that whether since the assessing officer has simply rested his conclusion on act of assessee having offered additional income in the revised return and has failed to take any objection that the declaration of the income made by the assessee in the revised return and his explanation were not bona fide, penalty imposed upon the assessee was not justified and has rightly been set aside by the appellate authorities, hailed yes. So this judgment once again is in favor. The entire text is in front of you. I'm not reading the entire text now. So the entire text is with you. The entire relevant part of the text is with you. Second is such other judgment is in case of Bombay ITAT, Rajesh C. Gandhi, 2010, 38 SOT 537. We have one more judgment. One more judgment in the case of Bansal, 2017, 83taxman.com 332 Delhi Tribunal. So my submission here is looking towards this judgment, one may take a view that if it is one person surrenders just to buy peace of mind and to come out of this protracted or long lasting litigations, and he pays the tax, probably he may have a case that he may be protected from a penalty. Please note that the Ahmedabad ITAT judgment which I referred above can be distinguished on the ground that number A, the income which I have received from an LIC, generally one has a belief that whatever that comes from an LIC is an exempt income, and my case may falls in an except. I was not aware that my case falls in an exception, and I was being made aware only when the notice came. So I accepted that my case falls in an exception and I am ready to pay the tax. So the bona fide belief, one can digest that it was a bona fide mistake. So far as donation in the political party, when I said that I given a donation to a political party and that a political party donation turned out to be a bogus donation, was that my bona fide mistake? I have all my doubts that it may be accepted or it may not be accepted. But similarly, as I mentioned that there is one judgment of Punjab and Haryana High Court, and in the Punjab and Haryana High Court it is absolutely a case where there was a sale of shares and it was found that the sale of shares was not something which was genuine. He surrendered that income. So this case falls somewhere in the line of the case of bogus donation. So this all judgments one must consider before responding to the notice under section 148. What I try to convey here is that if one takes a view or one wants to take a view that he just surrenders income without accepting the allegation that the donation to be bogus just to buy peace of mind, Please note that I am not here commenting that whether your donations are bogus or not. I refrain from commenting whether your donations are bogus or not. So I'm not going into that precise facts. I simply submit that if somebody takes a view that he does not want to go to the long lasting litigation because the cost of the litigation is on a very high side and the amount of tax and interest involved or the stake involved is too less, if he wants to buy a peace of mind and that he is ready to pay the taxes and to buy a peace of mind and doesn't want to get into that litigation, then probably he may have a chance and he may apply those particular judgments. Whatever I convey here is my understanding of the law, which may be wrong or which may turn out to be wrong in a time to come. So please consult your tax consultants, tax advocates, chartered accountants, or legal advisor before taking a decision. Hope that this video would be of some use to you. I read this judgment today in the morning, so I thought immediately to prepare a video for the benefit of one and all. Thank you very much. Take care. Wish you all a great time ahead.